5 to 4. I think it could very well be unanimous, or at least 7 to 2 or 8 to 1. If they go beyond that, though, I think it's going to be quite a mess.
Okay, Shane, we've emphasized here that the question before the court is only a small part of what's at issue with the material support statute and the problems that peacebuilding groups and human rights groups have found. If you could just give a brief overview, if the court were to rule in your favor, of what legislative reform you might still be seeking for the statute.
Right. Well, as Steve said, the court could very well, sort of affirm what the Ninth Circuit, has done here, which it has done repeatedly since 2000 on the vagueness front. In which case, we'd be seeking, something legislatively that reaffirms that principle from the Communist Party cases about vicarious liability, how you can't hold someone liable without, if they don't have specific intent to further the illegal ends of the organization. Now, that won't save everything. I mean, there could be pure political speech that is that sort of thought that we hate that, in fact urges someone, sort of to, further the illegal ends of an organization. And that problem is still out there. But for our plaintiffs, that's certainly a narrow solution, which is one reason we're hopeful maybe the Supreme Court will actually do that here.
But things like expanding the exemption from
Sure.
material support statute?
Yeah, there are a lot of things, and I think the best place to go look for these is a report that Kay Gwinnaine's group, the Charity and Security Network, has put together. Certainly things like exempting specifically medical services, the kind of forms of humanitarian relief that you spoke about in the introduction. Those would all be extraordinarily useful. And in the past, what's happened every time the case has gotten past a Ninth Circuit panel, Congress has intervened and tweaked the statute a little bit, and unfortunately, it's usually been 2 steps backwards with 1 step forward. This is the one time it hasn't happened, which is why this case has now gotten up to the Supreme Court. But we're hopeful that Congress would take a more comprehensive approach, and certainly one that's more responsive to what the aid community wants to do.
Okay, Lisa, and if you could just give us some examples, if the court were to rule in favor of Humanitarian Law Project, of how that might free you up in a way, what kinds of things might you be able to do on the ground, or the groups that you work with, that you're not able to do or not sure if you're able to do right now?
Well, we can join our European and Canadian colleagues doing things that they're already doing. And there are also restrictions that they face, and sometimes their government says, we know you may be doing something that's technically illegal, but they communicate directly to the NGOs, but we want you to talk with these groups. So just know that we are going to look the other way, and you do it and just don't talk about it publicly. So that kind of communication, even with the government, I think is an evolution of this that needs to happen. Clearer channels of NGOs sharing what we're doing, being transparent about it with key people who would want to know.
Okay, I'd like to open this up to questions from the audience. We have a microphone in the aisle, so if people who do want to ask questions would please work their way there, especially since we are being recorded. It would be particularly helpful. And when you do ask a question, if you could, first of all, identify yourself, and if you could also make sure to actually ask a question.
Or at least end your comment with a question mark.
And while we're waiting for people to get up there, I will ask one more question for the panel, since I don't see people there yet. Shane talked a bit in his opening about the hypotheticals that have come before the court and the questions that are out there. And I'm wondering if any of our panelists would like to take a crack at telling us how you would draw the line as to what, under a proper interpretation of the law, not the existing or what the government is arguing in its briefs, but if you were to say what the Constitution should permit, should not permit under the First Amendment, where you would draw the line between conduct that should be protected by the First Amendment and conduct that would actually be supported terrorism that could be prohibited consistent with the First Amendment. You don't want to touch that.
I mean, I think that when you clear away the statutory underbrush, right, and what I mean by that is when you clear away the fact that what is really lurking over this case is Congress's continued use of terms that are not easily defined, I think what you see is actually a really hard question lurking in the background about where the line is between protected speech and unconstitutional, and unprotected and therefore proscribable conduct in support of terrorist groups. My own personal view is that the answer, whatever the answer is, it requires an awful lot of legislative specificity, right? That Congress actually can do a lot in this field by simply speaking more clearly. And that, it is telling that despite the sort of popular and public understandings of this case, the real issue before the Supreme Court is not the sort of Scales guilt by association debate, but it is whether average ordinary citizens understand what it means to provide service or personnel, right? If Congress actually were to find ways to legislate more clearly, I think it could move the line much closer to where the government would want it to be than certainly where it is today. That's just my view, though. I was trying to provoke you.
Yeah, I mean, my gut sense here is that what the government really, that what Congress was really after might be, well, let me step back from that a little bit. I mean, Congress did add something to this statute. I think it's 2339B subsection I. That is essentially kind of a First Amendment safe harbor. It says that nothing here should be construed to prohibit activities that are protected by the First Amendment. Now, generally, courts don't give a whole lot of credence to that when there are vagueness problems with the rest of the statute. But standing kind of arrayed against that is this notion that the government promoted throughout the litigation below, that their intent is really Congress's intent was really to make these groups radioactive. And think about that in the context of some of the other hypotheticals, like working with Greenpeace, an organization that engages in illegal activity, inside and outside of the United States, I suppose. Can you freely criminalize all sort of coordinated activity with Greenpeace? I mean, that would be consistent with making a group that engaged in illegal activity overseas radioactive. And again, I think that just sort of comes up right against all of these Communist Party cases, or the real sort of the fundamental gist of what those cases are all about. So I'm not sure that necessarily narrowing it is the best thing. I think that's one of the interesting things that'll certainly come out at the argument, whether or not a narrower statute is, or a statute with more specificity sort of laid out is in fact any improvement.
This is a bit of an aside, but it's related because of the free speech First Amendment. In Afghanistan, there was some discussion in our group about what if we did the training on Afghan television, on negotiation training, and what a peace process included. Because this is it general knowledge or specific knowledge? Again, it's unclear, but if you're doing something on national television because you want the entire public, including the Taliban, to know what a peace process, what the components of it make it successful are, and how to negotiate successfully. It's just an interesting thought. If we did it over the television, is that okay instead of doing it in person?
Is it support too?
Yes.
Or is that just something that restricts the services limit?
Just really quickly, but just to add why I think it is so hard to answer some of these questions and to sort of play prognosticator, I think it's also important to remember this is the first terrorism-related, or at least specifically terrorism-based, criminal case the Supreme Court is hearing since September 11th, right? They've heard cases about terrorism as a sentencing enhancement, but that's it. And so, the court, it's hard to sort of predict where the court is going to be and whether those who are traditionally skeptical of vague statutes, even on the more conservative side of the spectrum, might let down their concerns in the context of terrorism. I mean, so that's part of why the atmospherics here are so, I think, tricky and difficult to project.
Okay, I see we do now have a line at the microphone. So again, reminders to please identify yourself and to please actually ask a question.
Thanks, Sharon. I'm Karen Grisey. I'm at the Fried Frank Law Firm here in Washington, D.C. Shane alluded a little bit to the material support context in the material support concept in the asylum and inadmissibility context, and I wanted to ask, given that the outcome of the case that you're talking about is far from certain, I wondered if you could